What if the biggest threat to Lil Durk's freedom isn't one witness, one piece of evidence, or even one shocking piece of digital information, but all of them working together? Because as Lil Durk's federal murder-for-hire trial gets closer, prosecutors are reportedly preparing to bring approximately 35 government witnesses into the courtroom. And that number alone has people talking. But here's the part that makes this situation even more serious. The government's case isn't apparently built around 35 people telling the exact same story. Instead, prosecutors are expected to use different witnesses to establish different pieces of an alleged conspiracy: motive, communication, travel, surveillance, money, and what allegedly happened before and after the 2022 Los Angeles shooting. As for Durk Banks, better known to the world as Lil Durk, the difference between those pieces connecting and falling apart could be enormous. His defense team is one of the strongest in the business, but even an elite legal team now has to deal with a mountain of evidence that prosecutors have spent years assembling. And with the trial scheduled to begin on August 2026, the clock is almost out. So how did Lil Durk get here? And what exactly are these 35 witnesses expected to bring into the courtroom? Let's break it all down. Lil Durk isn't just another rapper facing a federal case. He's the founder and face of Only the Family, a Grammy-recognized artist and one of the most influential voices to emerge from Chicago's modern hip-hop scene. But his career has also been deeply connected to the people around him, especially King Von. When Von was killed in November 2020 following a confrontation involving Quando Rondo's camp, the loss sent shockwaves through Durk's world. Prosecutors now allege that the death created a motive for retaliation. According to the federal government's case, Durk and others allegedly became involved in a murder-for-hire conspiracy targeting Quando Rondo. The alleged attack happened on August 19, 2022, near the Beverly Center in Los Angeles. Gunmen opened fire at a vehicle associated with Quando Rondo. Rondo survived. His cousin, Xavier Robinson, known as Lul Pab, was killed. Federal prosecutors allege that OTF associates tracked the intended target, used multiple vehicles, and fired at least 18 rounds during the attack. But there is an extremely important point that cannot be ignored. Lil Durk has pleaded not guilty to the charges, and he is presumed innocent unless the government proves its case beyond a reasonable doubt. That is the standard that will ultimately decide this case. And after years of investigation, prosecutors are now preparing to put their evidence in front of a jury. The trial date has already moved several times. It was initially expected to begin earlier in 2026, but after a series of pretrial disputes involving scheduling, discovery, and other legal issues, the case eventually landed on August 2026. Judge Michael W. Gerald has indicated that the trial is expected to proceed on schedule, with opening statements potentially beginning as early as August 21. That means the final pretrial decisions are becoming extremely important, because once the jury enters the courtroom, whatever evidence survives these hearings becomes part of the actual battle. And this is where the reported 35-person witness list comes into play. When people heard that prosecutors had approximately 35 witnesses, the internet immediately started calling them snitches. But legally, that's not necessarily accurate. A government witness list can contain many different types of people. Some may be cooperating defendants. Some may have first-hand knowledge. Others may be investigators, forensic analysts, records custodians, alleged victims, or experts who help explain specific pieces of evidence. A witness could authenticate phone records without knowing anything about the alleged conspiracy itself. Another could explain travel records. Another could discuss surveillance. Another could testify about communications, and someone else could provide testimony about events surrounding the alleged shooting. So the number 35 doesn't automatically mean 35 people are accusing Durk of the same thing. Instead, prosecutors can potentially use those witnesses like individual pieces of a puzzle. One person explains the alleged motive, another explains communication, another helps establish travel, another connects phone data to a particular person. Another explains what allegedly happened after someone arrived in Los Angeles, and another could provide context for financial transactions. That's what makes a large witness list potentially powerful. The prosecution doesn't necessarily need every witness to be a superstar witness. They need enough individual pieces to fit together into one convincing story. And that's exactly what Durk's defense team now has to attack. Leading that defense is Drew Findling one of the most recognizable names in elite criminal defense. His team also includes Brian Steele, who represented Young Thug during the lengthy YSL racketeering case in Georgia, along with Christy O'Connor. People have described Durk's representation as a million-dollar legal team, although that phrase should not be treated as a verified billing figure. What is clear is that Durk has assembled serious legal firepower, but the challenge is enormous. His attorneys have to examine witness statements, cooperation agreements, criminal histories, inconsistencies, communications, digital records, surveillance, travel records, and every possible connection between the government's witnesses and the alleged conspiracy, and they have to do all of that while the trial gets closer. Then there's the evidence itself. One of the major battles involves a cell phone seized following a 2021 home invasion in Georgia. Judge Fitzgerald ruled that federal investigators can use data extracted from that phone. According to the prosecution's interpretation of that evidence, the phone contains screenshots and messages that allegedly show people in Durk's circle tracking rival Lou Timo's movements and attempting to obtain his home address shortly after his release to house arrest. The phone also reportedly contains material concerning Quando Rondo's public schedule, including a concert flyer. The defense fought to suppress this evidence, arguing that the phone was unlawfully seized. The judge disagreed, meaning prosecutors can use the material as part of their case. Then came another major ruling. On August 13th, Judge Fitzgerald ruled that prosecutors could show the jury Durk's 2022 song and music video "Piss Me Off." Prosecutors argued that the song and its visual content are relevant to the alleged motive involving retaliation for King Von's death. The defense strongly opposed allowing the material into the trial, but prosecutors won that battle. That means jurors could potentially sit in a federal courtroom and hear the lyrics and see the visuals while prosecutors explain why they believe the material matters. But there's another side to this debate. Durk's defense can argue that artistic expression shouldn't automatically be interpreted as a literal confession or proof of criminal intent. That debate has existed for years, particularly surrounding rap lyrics and how they are interpreted inside American courtrooms. The defense has also sought to use experts, including Dr. Eric Nielsen and Dr. Lance Williams, to provide context regarding rap music and Chicago gang culture. Their goal is essentially to challenge the idea that lyrics, music videos, affiliations, or cultural references should automatically be treated as direct evidence of criminal conduct, and this distinction could become extremely important, because being associated with a particular music collective does not automatically establish that someone personally committed a particular crime. The prosecution has to prove the specific charges against Durk. That is where reasonable doubt comes into the picture. When you put everything prosecutors have been allowed to use into one picture, the defense has a difficult road ahead. The government's case reportedly includes cooperating witnesses, cell phone data, travel records, rental car information, financial transactions, surveillance material, communications, and expert testimony. Then there is the alleged Los Angeles attack itself. Prosecutors are expected to walk jurors through the alleged planning, the movements of the people involved, the vehicles, the gunfire, and what happened afterward. And behind all of that is a massive digital discovery. Prosecutors reportedly have more than 230 gigabytes of digital material and over 20,000 pages of investigative reports. Think about how much information that actually represents. As a single text message can be interpreted in several ways when it's viewed by itself, but prosecutors can try to connect that message to a flight record, then connect the flight record to a rental vehicle, then connect the vehicle to a location, then connect that location to a phone record, then bring in a witness to explain what the government believes those communications meant. That's how investigators create what can be described as a digital mosaic. Every individual piece might seem incomplete, but prosecutors are hoping the pieces eventually form one clear picture. And this is where those 35 witnesses become important. Digital evidence can show contact a witness, can potentially explain the meaning behind that contact. The travel record can show someone went somewhere. Another witness can potentially explain why they went. A financial record can show money moved. A cooperating witness might explain what prosecutors believe that money represented, when physical records, digital information, and human testimony all point toward the same narrative. Prosecutors can argue that the evidence isn't random, it's connected. But the defense doesn't have to prove that every government witness is lying. They have to create enough uncertainty about the government's overall story that jurors cannot unanimously conclude guilt beyond a reasonable doubt. And that brings us to one of the biggest questions surrounding the witness list. How many of those witnesses are actually cooperating? Because not every government witness is necessarily a snitch. If cooperating defendants are involved, however, their motives will become a major issue. Federal cases often involve defendants who plead guilty and provide information to prosecutors in exchange for some form of consideration. If witnesses in Durk's case made agreements, the defense can examine those agreements. They can ask what those witnesses were promised. They can ask when they first spoke with investigators. They can compare their earliest statements to later versions. They can look for inconsistencies, and they can ask the jury whether someone facing serious criminal charges has a reason to tell prosecutors what they want to hear. Prosecutors will have the opportunity to argue that cooperation doesn't automatically make someone's testimony false. A witness can have a criminal history and still tell the truth. The real question is whether that person's testimony is credible and whether independent evidence supports it. And there's another unusual wrinkle. A cooperating individual identified in court documents as co-conspirator 6 reportedly died in October 2025 before Durk's defense team had an opportunity to cross-examine him. His statements were connected to important events in the government's timeline. His death has therefore become a significant issue from the defense perspective, because cross-examination is one of the most important tools a criminal defense team has. If a person makes statements that prosecutors want to use but dies before the defense can challenge that person in court, questions about fairness and admissibility can become extremely important. So as August 20 approaches, the courtroom battle is becoming much bigger than simply 35 witnesses versus Lil Durk. It's about whether all of these pieces can actually be connected to Durk personally, and that's where the defense has its opening. Because prosecutors can bring a mountain of evidence, but a mountain is only useful if the government can prove that it leads directly to the defendant and satisfies every element of every charge beyond a reasonable doubt. And Durk's attorneys are preparing to argue that the government still has to make that connection. The trial is almost here. And when the first witness takes the stand, years of investigation will finally begin facing the one thing that matters most: cross-examination. If prosecutors really have approximately 35 witnesses ready to testify against Lil Durk, the biggest question isn't whether the number sounds overwhelming. It does. The real question is whether all of those witnesses' records, messages, financial transactions, travel data, and other evidence can be connected into one story strong enough to convince a jury beyond a reasonable doubt. Because that's the legal battle waiting inside that courtroom. And history shows just how difficult federal trials can be for defendants. Federal prosecutors have extremely high conviction rates across criminal cases, although exact rates vary depending on how they are calculated and because many defendants plead guilty rather than take their cases to trial. That matters here because federal investigations often develop over years. Investigators can build their case slowly. They collect communications, they examine financial records, they track travel, they interview witnesses, they analyze digital devices, they compare statements, and they can potentially use information from defendants who have already pleaded guilty. This can create what some people describe as a domino effect. One person faces serious charges, that person reaches an agreement. They provide information. That information leads investigators to another person. Another defendant becomes vulnerable. Another agreement follows. And eventually prosecutors can have multiple witnesses describing different parts of the same alleged operation. That appears to be the kind of environment Durk's defense team is now preparing to fight. But there has also been a major victory for the defense. In July 2026, Judge Fitzgerald severed newly added racketeering-related counts from the upcoming August trial. Prosecutors had attempted to include allegations involving a January 2022 Chicago killing and a 2019 attempted murder in Atlanta. Durk's attorneys fought against expanding the August trial to include those allegations, as the judge ultimately sided with the defense and removed those counts from the upcoming proceedings. That does not mean those allegations disappeared forever. They could potentially be addressed separately later, but they will not be presented to the jury in the current trial, and that is a significant victory. Why? Because one of the defense's biggest concerns in any criminal trial is the possibility of jurors hearing so many unrelated allegations that they begin judging the defendant based on an overall impression, rather than the specific charges being tried. Keeping additional allegations out can therefore prevent prosecutors from presenting a broader picture of alleged criminal behavior that the defense would have to fight on multiple fronts. So not everything has gone the government's way. Judge Fitzgerald has also questioned aspects of the prosecution's case. During a July hearing, he reportedly expressed concern about why prosecutors waited so long to bring certain Chicago-related allegations into the case. That matters because it shows the judge is not simply accepting every prosecution argument without scrutiny. At the same time, the defense still has major challenges. The cell phone evidence remains important. The Piss Me Off music video and lyrics are coming into evidence. The prosecution has its cooperating witnesses. The government has travel and rental car information. There are financial records, there is digital evidence, and prosecutors are expected to use gang-related expert testimony to provide context about OTF, relationships, rivalries, and the culture surrounding the alleged retaliation. But the defense is expected to push back hard against that narrative. Their argument can essentially come down to one critical distinction: association is not participation. Being part of a rap collective doesn't automatically prove involvement in a specific crime. Knowing about a feud doesn't automatically prove participation in a murder-for-hire conspiracy. Having lyrics that prosecutors believe sound violent doesn't automatically establish that the lyrics describe literal criminal conduct. And being connected to people who allegedly committed crimes doesn't automatically make someone legally responsible for those crimes. That distinction could become one of the most important themes in the trial. Now imagine how the 35 witnesses could potentially be organized. There could be cooperating co-conspirators, there could be investigators who built the government's digital timeline, there could be forensic analysts, there could be people responsible for authenticating records, there could be eyewitnesses, there could be experts explaining gang culture, and there could be witnesses who help prosecutors establish motive, planning, logistics, the alleged attack itself, and the financial side of the conspiracy. Each witness has a different job, and that's why the defense doesn't necessarily have to destroy every single witness. They need to identify weaknesses in the government's overall chain of evidence. Maybe one witness has credibility problems. Maybe another witness's timeline doesn't match a phone record. Maybe a financial transaction can be explained differently. Maybe a text message has an alternative interpretation. Maybe prosecutors cannot prove that Durk personally knew about a particular action. Maybe an expert's conclusions can be challenged. Maybe two witnesses tell slightly different versions of the same event. None of those things automatically wins a trial, but when enough questions accumulate, reasonable doubt can become powerful. And that's exactly what Drew Findling and his team are being paid to create. They can cross-examine every witness. They can examine every promise made to cooperating witnesses. They can investigate every inconsistent statement. They can question every piece of digital evidence. They can challenge the government's interpretation of Durk's music. And they can argue that prosecutors are taking individual pieces of evidence and trying to turn them into something bigger than what they actually prove. Now let's step back and look at how this entire story developed. November 2020, King Von is killed following a confrontation involving Quando Rondo's camp. The tragedy becomes one of the defining moments in Durk's life and career. According to prosecutors, it also becomes the alleged motive behind what they say was a later retaliation campaign. Then comes 2021. Federal investigators say a cell phone connected to a Georgia home invasion contains material suggesting efforts to track Lul Pab and monitor Quando Rondo's public appearances. Prosecutors believe that information helps establish planning and surveillance. Then August 19, 2022. Near the Beverly Center in Los Angeles, gunmen allegedly open fire. At least 18 rounds are reportedly fired. Quando Rondo survives. His cousin Lul Pab is killed. The investigation continues. Then October 17, 2024, Lil Durk is arrested in Broward County, Florida. Alongside several OTF associates, he remains in custody as the case develops. The government continues building its prosecution through additional indictments and extensive discovery, and the discovery becomes enormous. Hundreds of gigabytes of digital material, thousands of pages of investigative reports, travel records, rental car information, phone data, messages, financial information, and witness statements. By January 2026, prosecutors are revealing more about their cooperating witness strategy. The government says insiders are prepared to testify about how the alleged conspiracy was planned, funded, and carried out. Then July 2026 brings the defense victory. The newly added racketeering and Chicago-related allegations are separated from the upcoming August trial. The defense gets a significant piece of ground back. But then comes August 13th. Judge Fitzgerald allows the Piss Me Off music video and lyrics into evidence. The defense fights it, the prosecution wins that round. Expert witness issues are also being argued, and suddenly the trial is only days away. August 20, 2026 jury selection is expected to be finalized. The trial is expected to last approximately 2 to 3 weeks, and after nearly 2 years of pretrial battles, the case is finally moving toward the courtroom. That's why the 35 witnesses matter so much. The headline makes it sound like prosecutors have 35 people standing in line to say the same thing. But the reality is more complicated. Some witnesses may be central, some may only provide technical testimony, some may explain documents, some may authenticate evidence, some may provide context, and some could become major targets of cross-examination. The defense doesn't need to defeat a number. They need to create reasonable doubt. That's the difference. Imagine the government presents a witness who says a particular communication meant one thing. Then the defense shows that the same communication can reasonably be interpreted another way. Now imagine another witness provides a timeline. The defense introduces a phone record that appears to complicate that timeline. Then prosecutors bring in a financial record. The defense provides an alternative explanation for the transaction. One piece may not matter, but several disputed pieces can change the way jurors see the entire case. That's why the courtroom won't simply be about quantity. It will be about credibility. It will be about consistency. It will be about corroboration. And most importantly, it will be about whether the government can prove its allegations specifically against Lil Durk, because the burden belongs to the prosecution. Durk does not have to prove that he is innocent. The government has to prove that he is guilty, and it has to do so beyond a reasonable doubt. That is the standard. Now consider the jury. 16 jurors are being selected with anonymity protections because of security concerns surrounding the case, but ultimately the decision will come down to whether the required number of jurors can agree that prosecutors proved their case. They won't simply be asked whether Lil Durk is famous. They won't be asked whether they like his music. They won't be asked whether OTF has a reputation. They won't be asked whether King Von's death was tragic. They will have to evaluate evidence. They will have to determine whether witnesses are credible. They will have to decide whether the digital records support the government's theory. And they will have to determine whether prosecutors connected Lil Durk personally to the specific conduct charged. That's a much higher bar than simply creating suspicion. And that's where the defense has its strongest argument, because suspicion is not enough. A troubling message is not automatically enough. A music video is not automatically enough. As association is not automatically enough. A large witness list is not automatically enough. The prosecution needs to connect those pieces into proof, and that is exactly what the jury will be watching. The government will argue that years of investigation produced a detailed trail, a trail made up of communications, travel records, financial transactions, digital evidence, witnesses, surveillance, and other information. Prosecutors will attempt to show that those pieces reinforce each other. The defense will argue that the government has collected a huge amount of information but still has to prove Durk's individual responsibility for the alleged conspiracy. And that is the central conflict, not 35 witnesses versus one defendant.
Not the government versus hip-hop.
As not OTF versus Quando Rondo's camp. The actual legal question is much narrower. Did the prosecution prove the specific charges against Lil Durk beyond a reasonable doubt? That's it. Everything else is background. King Von's death is background, the rap beefs are background, the music is background, the headlines are background, the internet debates are background. Inside that courtroom, the evidence is what matters, and that is why the next few weeks could become one of the most consequential periods of Lil Durk's life. For years, this case has existed through court documents, allegations, social media reactions, and breaking news. Now it's about to move into the place where those claims actually have to be tested. A witness will take the stand. Prosecutors will ask questions. The defense will cross-examine, documents will be displayed, messages will be examined, experts will testify, and jurors will decide which version of events they believe has been proven. The government believes its years-long investigation has produced enough evidence to establish Durk's guilt. The defense believes prosecutors still have to bridge the gap between evidence surrounding an alleged conspiracy and proof that Durk personally committed the crimes charged. And that's the battle. So when you hear the number 35, don't just think 35 snitches, think about what those 35 witnesses actually have to prove. Because one weak witness doesn't automatically destroy a case, but one strong witness can change a case. Has one document can change a timeline. One contradiction can damage credibility. One piece of digital evidence can reinforce an entire narrative, and one reasonable doubt can be enough to prevent a conviction. The courtroom is where all of those pieces finally collide. August 20 is almost here. The government has its witnesses. The defense has its experts. The prosecution has years of investigative work. The defense has spent nearly 2 years preparing to challenge it. Some pretrial decisions have gone against Durk, some have gone in his favor. The piss me off video is coming in. The cell phone evidence remains a major issue. The additional racketeering allegations have been separated from this trial, and the reported 35-person witness list remains one of the biggest talking points surrounding the case. But none of that determines the final result. The jury does, and the jury will ultimately have to answer one question. Has the federal government proven beyond a reasonable doubt that Lil Durk personally committed the crimes he's charged with? Until that question is answered, everything else is speculation. The streets want answers. Hip-hop wants answers. King Von's legacy hangs over the story, but the courtroom has its own rules. And when the first witness takes that stand, the social media debate will finally give way to evidence. This case is about to enter a completely different phase, and whatever happens next could change Lil Durk's life, his career, and the way this chapter of hip-hop history is remembered. The trial is almost here, and this story is far from over.